public sector institutions. A full understanding of POPI and associate regulations will empower departments and institutions to take urgent steps to protect personal information and engage big data within the bounds of law. We are delighted to partner with the Information Regulator to bring to you the second session that we have in our series on unpacking the POPI Act. During this session, we are hoping that you will have an opportunity to engage the Information Regulator with the POPI regulations, with the exemptions from conditions for lawful processing of personal information, and as well the applications for prior authorization. All our guests who are joining us today are invited to ask questions on the Q&A platform at the bottom of your screen, or to engage with the panelists through the chat box. Please feel welcome to our session and be engaging and interactive as possible. I would like to invite our Deputy Director General, Dr. Botshabelo Maja, from the National School of Government, to give you our opening remarks and welcome address. Dr. Maja, over to you, please.
Thank you very much, Ms. Lapan. Good morning, colleagues. Good morning, everyone. Welcome to the partnership between the National School of Government and the Information Regulator. Let me take this opportunity to welcome our colleagues from the Information Regulator. This is part 2 of our engagement webinar looking at the Protection of Information, Personal Information Act. We do this as part of our endeavor as the National School of Government to not only empower public servants in doing their jobs better, but to make sure that public servants themselves as citizens of this country know the difference between right and wrong, understand what they need to do, and how can we be able, all of us, to move ourselves towards the space that we call execution diligence. What that requires is that we need to know what the rules of the game are, how are we going to work with those rules to make sure that we achieve the objectives that we've set ourselves to achieve, and how are we going to make sure that we build this capable developmental state that we always talk about. We are 9 years away from 2030. We've agreed on a vision for this country, which will culminate, hopefully, in us achieving our goals by the year 2030. We've just come out of the local government elections in the last 5 days, and all of this means that all of us who are here need to fold our arms and make sure that our hands are on the wheel to assist not only government, but the state in general, and also the country to achieve our goals and objectives. The Protection of Personal Information Act that we'll be talking about today is one such lever that will make sure that we move in one direction, respectful of personal information, respectful of the bounds of sharing of personal information, respectful of the rules that guide and govern the sharing and utilization of personal information. We have a number of colleagues in the legal fraternity who will be speaking to us during the course of today, and we hope that by the end of this session, we will all know better about what we need to do and how can we be able to execute diligently. We are happy you are here because it means that all these sessions that we've been having are beginning to bear fruit in ensuring that all of us as public servants inform ourselves, educate ourselves, develop ourselves, capacitate ourselves to be able to know better what we need to do. We had in the last few weeks a similar webinar, which was attended to by Dr. Cassius Lubisi and Dr. Lee on the very essence of how and what we need to do to build these capabilities that we talk about, and how can we learn from countries such as China that have been able to do it. In the next week, we invite you again to join us on Wednesday next week, as we will be launching a book that has been published by the National School of Government on Black youth aspirations. We're talking to the issue of Black youth aspirations next week, similarly to the issue of building a capable state, because we cannot afford to have a youth in our country that is disengaged. The participation and the voting trends that we've seen on Monday are a cause for concern. We need to bring back all South Africans to participate in our democracy, to be active in our democracy, and to be joint players in the building of this country that we all love. So sit back, hopefully relax, hopefully enjoy, but more importantly, learn and use the learnings out of this webinar today to build your capabilities towards executing diligently. All the best, and I'm looking forward to listening and learning myself, and I hope we can all do the same during the course of this morning. Thank you very much, Ms. Lepan, and all the best for the session.
Thank you very much, Dr. Marja. And just to introduce myself again, I'm Louise Lepan. I'm the Chief Director responsible for senior management and professionalization, professional development at the National School of Government. Please feel welcome. Our participants are up at 622, and this is all part of your professional development being introduced to this particular act. We would like to know a little bit more about the information regulator, and it gives me great pleasure to welcome Advocate Weapons, Colin Weapons. He is an admitted advocate of the High Court of South Africa. His areas of specialization include information technology, risk management, forensic investigation, compliance management, business management, and law, with specialization in the law of contracts. He's a full member of the Information Regulator, and I'd like to welcome him to tell us a little bit more of the work of the Information Regulator. Over to you, Advocate Weapons, please.
Good morning. Thank you so much. Good morning to all the participants, and good morning to my colleagues from the Information Regulator, as well as other colleagues, which gives me great pleasure as well. Colleagues, just to, by way of an intro, I'd like to just inform you that Mr. Nemasisi and Advocate Moale are responsible for the processing, basically the protection of personal information, and Mr. Nemasisi is responsible for the promotion of access to information. They are both executives. They are also joined by senior managers, and these senior managers include Advocate Ludidi, Mr. Makubela, as well as Ms. Lamula. And in saying all of this, it's also very important to note that this is the A team of the Information Regulator, and they are quite knowledgeable about the Protection of Personal Information Act. Thank you so much. So what is the Information Regulator done so far? The Information Regulator has basically ensure that regulations have been drafted, guidance notes have been published on our websites. There were also various strategic stakeholder engagements that were conducted, including the one that we see today. There's also the engagement that we had that Ms. Lupan referred to, which is actually the one that actually provide some concerns about what will be the consequences if you take a photo in a group, or if you take an individual photo and your consent has not been provided. So those are some of the key areas which we still need to engage on further. But in saying this, and to bring you back to POPI, the information regulator is quite mindful of the fact that the Act is quite technical and at some points difficult to interpret. And the information regulator is also making a list of some of the errors, some of the issues and some of the complications around cross-referencing in the Act. By way of an example, if you read section 1122 C, it would refer you to section 32.6, and section 32.6 would refer you to section 32 1B and 1F. And that type of cross-referencing makes it extremely difficult for people to implement, to understand, interpret, and implement POPI. But the regulator is working on trying to get all the areas of concern so that it can also effect wholesale changes when the time is permits. Colleagues, in saying all of this, there are instruments and measures that are provided for in POPI that public and private bodies can use. Some of those instruments and measures includes developing a code of conduct. You can also apply for prior authorization. That there's exceptions that you can rely on. There is exclusions and there are exemptions. And all these measures are supposed to be used in the circumstances that the Act provides for. And what is also very important to appreciate is the fact that there are guidance notes that the information regulator publishes from time to time. These guidance notes are particularly important for public and private bodies to understand how the regulator thinks and how the regulator appreciates, for instance, and by way of an example, information officers and the appointment of deputy information officers. And that specific guidance note provides some insights about, but not limiting any public or private body with regards to the number of deputy information officers that can be appointed. And in saying all of this, the information regulator is also looking at bringing into effect section 57.2, which refers to prior authorization, and that will happen from the 1st of February. And that particular section is the only section that has not yet been called into effect. And as such, the information regulator will then ensure that that particular section comes into effect as per the stipulated date of the 1st of February. What is also very important for us to appreciate is that the information regulator is having these continuous webinars and stakeholder engagements so that all the different stakeholders can have access to the information regulator, and that also speaks to the limited resources that the information regulator has from time to time. But what is also very important and what is also key to appreciate is the fact that every responsible party, being a public or private body, the starting point will always be what I would call an assessment, or some people call it a gap analysis, and that speaks to the privacy impact assessment, as they call it in Europe. In South Africa, we call it a personal information impact assessment. And that specific exercise will then provide any and all responsible parties with a clear understanding of the gaps that could or are existing within their processing systems, be it the technology side of things, which are the electronic systems, or your physical processes, your traditional processing method. And that will always culminate in what we would call a framework. And that specific POPI framework will then be the one that responsible parties are supposed to implement and monitor so that compliance can be improved. And in saying all of this, colleagues, it gives me great pleasure to hand over to our executives so that they and the team that they have selected in the form of Mr. Makubela, Mr. Advocate Lutidi, and Ms. Lamula can then provide you with an expert position of the information regulator with regards to certain aspects of POPI. Thank you so much once again, and over to the team.
Thank you very much, Advocate Weapon, and for introducing us to the information regulator. So one of our guests this morning was saying we are now in a webinar session 2, and will that mean that I cannot continue? So please stay and join us for webinar 2. We will cover some of the ground, a few of the slides will cover some of the ground that we've shared with you in session 1. So you for sure will not be lost as we progress through webinar 2. Please stay, please engage, and please ask the questions to our esteemed panel. Thank you very much as well, Advocate, for raising that issue of group photographs, the implications of Facebook, of Twitter, and social media accounts. In the main, our session today will also assist government officials on what these regulations will mean for them as they process personal information. I'm going to hand over now to Advocate Mohali, who is going to talk about the POPI regulations. Advocate Mohali, can I just check if you'd change the display settings so that we get a full screen like we did? And then over to you, Advocate Mohali. Ladies and gentlemen, please engage in the chat box and the Q&A. The team are waiting to receive your questions. Please check the display setting there, Advocate Mohali. Over to you. Advocate Mohali, are you there? Thank you very much.
I'm here. Good morning. Can you see my screen?
Yes, ma'am. Thank you very much.
Mode?
Yes.
Okay.
Thank you.
Good morning, all. Advocate Weapon, member of the Information Regulator. Good morning, Dr. Maja, DGG of the National School of Government. All DGGs present, as well as distinguished guests and my fellow colleagues at the Information Regulator. So as mentioned before, today we're going to speak about the POPI Act, and I'm going to focus on the regulations. I will touch a little bit on the overarching principles of the Act. Okay, so the purpose of the Act, it is to give effect to the constitutional right to privacy of all data subjects meaning natural persons as well as juristic persons. And this is in balancing the right to privacy against all other rights, particularly the right of access to information, and protecting important interests, including the free flow of information within the Republic of South Africa, as well as outside. So as I mentioned, the role players within POPI, your data subjects, that is your natural and your juristic persons, your responsible party, which are the people that are responsible for processing of information. It can be a private or a public body, and they can do it together or with another responsible party. And then you have the operator, who is the person, also natural or juristic, who processes personal information for a responsible party in terms of a contract or a mandate. It is important to note that we have 8 conditions of lawful processing. Just an overview: you've got your accountability, as in how is it that you are complying with the Act in total. Then we go into the specific sections where condition 2 is processing limitation, ensuring that we do not process beyond that which we need. Also, at purpose specification, we must specify the purpose for which we are processing people's personal information. Further processing, we should not go beyond that purpose that we have stated in our initial collection. Then we have information quality, ensuring that we keep information up to date and accurate at all times. Openness is a transparency condition to ensure that we are open with data subjects as well as other interested parties in terms of what information we are collecting, how we are collecting it, if any, are we sharing it with anybody or even transferring it outside South Africa. Security safeguards is a 7th condition, and it is to ensure that responsible parties retain information or share information in a secure manner that does not infringe on the data subject's right to privacy. And in that, we also have one of the most important is the data subject participation, that the data subject should be able to consent or where information is being processed on other lawful grounds, they should be able to request that the information be recorded accurately and deleted where they no longer want the information to be processed, right? So the implications of POPI for government departments is pretty much the same as with all other responsible parties. The Act applies indiscriminately to public bodies as well as private bodies. And there are certain exemptions that are enjoyed by public bodies. We will find those in Section 6 and in Section 38. As I mentioned, I am just going through this to remind people what was happening in the previous webinar. My main focus today is on the regulations, and I will touch on the aspects that I think are vital for a public body, also a responsible party, to be aware of. So as I mentioned that we have the data subject participation, I will start with Section 11, which speaks on consent, justification, and objection. So we need to have a lawful ground upon which we can base our processing of personal information. And in terms of the objection of a data subject, you'll find that also in Section 11, a data subject may object at any time to the processing of their personal information in terms of subsection 1D to F of Section 11 in a prescribed manner on reasonable grounds relating to his or her particular situation, unless, ladies and gentlemen, legislation provides for such processing. If in the instance that we have a legal obligation to process information, and should we not process that information, as a responsible party, we will be non-compliant with that one. We need to process that information, and the data subject cannot object to that processing of information. There is a form that a data subject can complete in the regulation that they can request this from the responsible party. And that's your information in general, right? Then we have in Section 69, specifically speaking to direct marketing by means of unsolicited electronic communications. I know there's a lot on the screen, do not fear. We're not going to go through that line by line. It's just to bring to your attention what it is that we are speaking about. So in terms of the data subject's right to object, when we are direct marketing, we need to ensure that we have consent in terms of subsection 1. We need to ensure that the data subject has not withheld such consent. And then where we in subsection 3 are dealing with an existing customer, we need to ensure that when we do direct market to them, they have also not previously opted out, objected to the processing of their personal information, and they must be given an opportunity in each communication to object to that information being processed. So those are basically the sections that are dealing with objecting of processing to personal information by data subjects. The next topic that I would like to touch on is our information officers, right? So in terms of POPI and PIA, a public body must appoint an information officer. The default position for information officer is always your head of the body. So I will take you through now who can be designated. The information officer, which is the head of that body, can designate to another person, and that person, in terms of POPIA, ideally can only take up their duty after the responsible party has been registered with the regulator. We had technical issues with the registration of information officers as well as deputy information officers with our portal. We are now processing all those applications manually, and the address is on our website should you require it. In terms of who can be an information officer within the public body, at national department, it can be the Director General or the person acting as the Director General. Your presidency or national government component, we've got also your Director General. At provincial department, we've got head of department. We've got the Director General or acting person at the office of the Premier, your municipal manager at the municipality, and your chief executive officer in public institutions. And also those persons that are acting in that role. So what is the role of an information officer in terms of POPIA as well as PIA? It is to encourage compliance with the conditions for lawful processing of personal information. The information officer, ladies and gentlemen, is not responsible for compliance, ensuring that the organization complies with the lawful, but to encourage and enable the public body to comply with the processing of personal information. They also need to conduct a personal information impact assessment. Advocate Weapon spoke to this earlier when he was introducing us, to say that this is necessary for the public body to be able to understand what is it that they are processing information for, and how do they need to comply with the POPIA. So what measures do they need to put in place to ensure that they comply, and this needs to be done before they actually start with the processing. And then there are requests that the data subject or even the regulator can make to the public body, and the information officer would then act as their contact person. They would need to ensure that a compliance framework is developed, implemented, monitored, and maintained. So this is an ongoing process. It's not a once-off thing, just drafting the framework, but also making sure that as the organization matures in its compliance with the legislation, and as processing changes, because we're living in an environment where things are changing regularly, to ensure that the framework is always updated. And we need to ensure as information officer that the framework is monitored and being adhered to. So it's a living document. It needs to be fit for purpose, right? The information officer also has to ensure that a PIA manual is developed, and like with the framework, it also needs to be monitored, maintained, and most importantly, it needs to be made available to anybody who may seek it. And how it is made available, the legislation does not prescribe, but most responsible parties have the PIA manual published on their website, where it can be accessed 24/7. It also can be accessed most organizations as well, from members of the public or persons coming into their office physically to request this. Other aspects of the information officer, yes, they are liable. They can, on conviction, be held criminally liable for specified offences. Those will be found in the Act as well, in POPIA as well as in PIA. And POPIA specifically empowers Enforcement Committee to make any recommendation to the regulator that is necessary for the regulator to ensure that the organization complies with POPIA as well as with PIA. I did mention earlier that the information officer can designate at least some of their responsibility to a deputy information officer. So each public body must at least have one person appointed as a deputy information officer, as is necessary to render the public body as accessible as reasonably possible for requesters of its record. So if the public body is quite small, they need not have 5 deputy information officers as with larger bodies, but depends on what information and how the information will be requested. They should they have the discretion to decide how many deputy information officers that they need to have. There are some conditions to the deputy information officers. It can only be an employee. For multinational companies, and I suppose we don't have that in the public body, this person must be situated within South Africa. The appointment has to be in writing, and it is recommended that it also form part of their job description so that they can be held accountable for all the duties that they need to perform. And these duties are determined by the information officer. This person also needs to be given sufficient time, adequate resources, and the financial means to be able to do their job. They need to have a certain level of authority. It is recommended that they report to the highest management level, and that they also themselves be at a management level. Management means different things to different organizations, but if we were looking at a CEO, then the deputy officer would also be a person who is on the executive committee of the organization. And the person needs to have reasonable understanding of POPIA as well as PIA, so that they can, with their understanding of the business operations and processes, be able to align and accurately ensure that the company complies with both POPIA and PIA. They do not need to be experts in this, but they need to have reasonable understanding of the requirements of the legislation. And obviously they will need to be given training, and training is ongoing. I think data privacy globally is a new discipline, and there is constant information flows. There's constant new information coming in. So the person needs to have that training. It is quite vital. So that's it on deputy information officers. I'd like to touch briefly on the code of conduct. So POPIA requires that, or allows responsible parties to have a code of conduct that will basically not necessarily exempt them, but allow the persons that are bound by that code of conduct to comply with POPIA through that code of conduct. So the code of conduct must incorporate all the lawful processing of personal information. It cannot just choose some, because the people bound by the code will be following that code. The code of conduct must prescribe how these conditions for lawful processing are to be applied and complied with. in the specific sector. So a code of conduct may apply in relation to any one or more of the following. So it has to be a specified information or class of information, body or class of bodies, activities, class of activities, as is mentioned there. And the code of conduct also has to, did I miss something? Okay, so in terms of applying the process to apply for a code of conduct to be approved by the regulator, the responsible party must complete a specific form for the code of conduct, provide their code of conduct as they proposed to the regulator, and in there provide what type of information and how they are going to comply with this, as mentioned in the previous slide. When the regulator receives the proposed code of conduct, it has to send this out for public comments. The code of conduct will be published in the Government Gazette, as well as on the regulator's website. The public is given some time to comment, and within 13 weeks from the publication of the proposed code of conduct, the regulator has to give its decision whether it will approve the code of conduct or it rejects it, and the applicant responsible party would need to apply again. And then the other matter that we would like to discuss in the regulations is consent. Consent, I touched a little bit on it in earlier when I was speaking about section 11. Consent is a ground for lawful processing of personal information, and consent must be given voluntarily, it must be specific, and it must be informed. If we go into section 18, it says that we need, when we are collecting information, we need to disclose to the data subject what information we are collecting, what we are collecting it for, how we're going to process it, and if we are going to share it with anybody. The consent must be given freely. You cannot expect a person that is under your control or your influence to consent freely to certain things. This would be mostly found in a employer-employee relationship, where the employer will request the data subject or the employee to consent to certain activities when they don't really have a choice, because should they not consent, then they will fear that their job is at stake. The consent, ladies and gentlemen, also has to be specific. We cannot be vague to say that we will use your information to further the activities of the responsible party. No, it has to be said that we will use this for, if we get in your tax information, we get in your tax information so that we can comply with SARS and pay your tax over to SARS. We will keep your information for so long. So in that, it was also saying that you need to inform them, allow the person to make an informed decision. It will help us in a very long way. So in terms of consent, as I mentioned earlier, it is one of the lawful grounds for processing of information. A minor child cannot consent to any processing of information. I saw that quite a few people here are from or have legal backgrounds. So a minor child is not considered to have legal capacity, and they can also not make decisions. And one of the things that we need to consider is that when it comes to perhaps the medical treatment and other decisions in there, the child can consent to their own treatment without the requirement for a legal guardian or a parent to be there. But POPI does not allow for that child who's under 18 to consent to the processing of the information. So a responsible party would need to balance those, because remember, POPI is principles based. You need to, as a responsible party, make a decision in terms of how you are going to deal with that. So the other grounds for lawful processing are mentioned there, and specific to public bodies, the processing is necessary for proper performance of public law duty by a public body. So there are instances where we can lawfully process information as responsible parties without having consent of a data subject. But it has to be quite clear when we put that in our personal information impact assessment, that is the basis upon which we are processing that specific information. It is not on all grounds that we can use that. So that's that on consent. And then POPI also speaks about complaints. Complaints to the responsible party being the public body. Although the regulation says that anybody, any person can complain to the regulator, I think it would be, in terms of other legislation that is protecting consumers, it would be wise for the responsible party to encourage people to complain to them and exhaust internal complaints resolution process. They can also be complaining to the information officer or the deputy information officer, as is seen by the responsible party. However, as mentioned, complaints to the regulator, any person may submit a complaint to the regulator. It will be in this prescribed form, and they obviously need to, in detail, provide what it is that they view as interfering with the protection of their personal information or another person's personal information. And ladies and gentlemen, there we need to ensure that where you complain as another person and not the data subject who is directly impacted by the interference of their information, you have a lawful ground, or as we call it, locus standi, you have the authority and you are competent to act on that person's behalf. Because as the regulator, we need to ensure that we do not flout our own legislation by allowing and sharing information with you on another person. When you complain, you're obviously going to give us the person's name, you're going to give us other personal information, and with that, it falls into the ambit of the POPI, and we need to ensure that we also comply with that. So as I mentioned earlier, that the complaint would need to be in a prescribed format, and the regulator will then, on receipt of that complaint, conduct a pre-investigation where necessary. The regulator can act as a conciliator and ensure that there's an amicable solution between the responsible party and the data subject, and also decide to take no action, conduct a full investigation, or refer the complaint to the enforcement committee. There are instances in terms of a due process where the regulator has no jurisdiction, or the regulator does not even have enough information for it to make a decision or take action. Sometimes there are people who complain and do not give us enough information, or even the responsible party's identity. And without that, we cannot go further with that complaint. And then for the purpose of investigating a complaint, the regulator has powers to summon and enforce the appearance of persons before the regulator. The regulator has the authority to administer oaths. We can enter and search any premises, and we can also search and seize, obviously with the lawful warrant, and seize any record, any equipment where we suspect personal information is being recorded on, retained on. And ladies and gentlemen, without much more, that is my presentation for this morning. And I would like to hand over to my colleague, Advocate Deborah Lamola, who's going to speak to the other aspects of the presentation. Thank you, Ms. Lepan.
Thank you very much, Advocate Mohali. There's a number of questions in the chat box and we are taking note of it. One of the big questions is the presentations, if the guests will be able to access the presentations. We are indicating that as a yes, and we are going to email the presentations to the emails that our guests have provided on the registration form. So all the questions relating to having access to the presentation and having access to the recording of the sessions, please note the NSG will make that information available to you on the emails that you've provided at the registration form. Ms. Lamola, can I please check if you would put the slide on slideshow? And then I would like to welcome you to talk about the exemptions from the conditions for lawful processing of personal information. Over to you, Ms. Lamola.
Thank you very much, Ms. Nepal, Lepan Askis, and greetings to everyone who is in the webinar, and in particular, respectfully to the distinguished guests. And thank you very much for Advocate Mohale. And I think you have actually laid a beautiful foundation, and mine will be just to go to the specifics on exemptions from the conditions for lawful processing of information. Ladies and gentlemen, you'll realize that even when Advocate Weapon was introducing us as a regulator, he did mention that one of the complexities of POPI involves the need to cross-reference the pieces of provisos. So for one to finally get to comply in the correct way. So our focus today, though, is on exemptions. So if we look at exemption in POPI, we do find that Section 36 provides that processing of personal information is not in breach of a condition for the processing of such information on two conditions. That is when the regulator grants an exemption in terms of Section 37, or if the processing is in accordance with Section 38. And this more or less is what this presentation will all be about. And Kitty there is also asking, can anyone be free from an obligation or liability imposed on others? And well, basically, that's what exempted means. So, but we will now be talking to that. Basically, we will, our topic will reflect on what exemptions are, the 8 conditions for lawful processing, and why should certain parties or responsible parties be exempted from complying, and how should the responsible party know that they should apply for exemption or not, and what should the responsible party do to be exempted. And more or less, we will touch on those things that are likely to be exempted as a regulator. Now we will encounter these common ways. I'm just, just mentioning them so that when I say POPI, we know that we're talking about Protection of Personal Information Act, as you know it, where the text refers to RP, we're talking about the responsible party. There's also the guidance note on exemptions from conditions for lawful processing of personal information, which is on the regulator's website. And in this presentation, we'll just be referring to it as the guidance note. The data subject or data subject, as others may say, just means a person to whom personal information relates. And that has been also elaborately explained by Advocate Mohali just prior to this. We need to be asking now, what are the exemptions? There are conditions that are set in POPI to relieve certain responsible parties from the obligations of complying with the 8 conditions for lawful processing of personal information. This has been outlined in the previous presentation, but I'll also, just for emphasis, outline them in this one. So now chapter 4 of POPI, as you go in there in your act, will find that it deals with this exemptions that we're talking about. And the general proviso is that of section 36, which, as I said just a while ago, that it speaks to condition A, which is that the regulator must grant a responsible party exemption in terms of section 37, or the processing of the responsible party must be in accordance with section 38. Now, why should certain responsible parties be exempted from complying? You know, colloquially, one could say the conditions under which they operate or process information would make it difficult to comply, or perhaps it may even be unreasonable to expect them to do so in full. But also it may be that the nature and functions they perform requires them to comply with certain laws, and the responsible party complies with those particular laws. We will be talking to this in the presentation. But then how should then the responsible party know whether they should apply or not? I think Advocate Mohali really went to details to explain the responsibilities of the responsible party and a lot of the other pertinent information. But simply, if you're able to check section 6 and 7 for exclusions, and as well as section 36, 37, and 38 of POPI, one will be able to get a glimpse of how should one know whether they really need to apply or not. And what you to be doing to be exempted. The information regulator is generous with procedural documents, and you would find that you have a guidance note, you have an application form. Now, at this stage, I would like to reflect on the application form, because that is what the regulator will use to determine the conditions that you will be talking about, and whether the exemption should be authorized or granted by the regulator or not. Now, when you have, or if you have perhaps already applied for this exemption, one would have seen that Part A of the application form requires details of the responsible party, including whether they are a public body, a private body. This is important. And Part B will speak to conditions for the lawful processing of personal information. Now, this in the form, ladies and gentlemen, colleagues, and everyone else, it requires the applicant to actually indicate, tick, which of the conditions for lawful processing one requires to be exempted for. And yeah, we have challenges, we'll talk about them later, where one needs to be exempted from everything. Part C, which I just say it's Part C1, will require the applicant to provide reasons why it is necessary for the responsible party to process personal information. To process information in breach of the conditions. Now, this part also requires in the application form for the responsible party or applicant to indicate the public interest in the processing of personal information that outweighs to a substantial extent the violation of the privacy of the data subject that could result from such processing, which is now in breach. And it must also now, if it finds that there is no space or there are other public interests that are not listed, we'll be touching on them in the other slides. You then have to specify what other public interest is that will outweigh the violation of the privacy or the processing in breach of the lawful conditions. You also require to indicate the reasons how the selected or the specified public interest in the processing will to a substantial degree or benefit the data subject. We will talk about this in the coming slides. You also have part 2C, which now speaks to benefit to the data subject or a third party. It should not just be the data subject that should benefit from processing information in breach of the lawful condition or conditions. It can be a third party that benefits from that processing in breach. But the applicant or the responsible party need to specify the nature of the clear benefit to its data subject or to the third party, and also explain how that the benefit or the nature of will be to the benefit of the data subject. Especially, I've highlighted there to a substantial degree. We'll be talking about the measure of public interest, and this one of a substantial degree in just in the slides that follow. Now, just to go into outline part B of the application form, you will notice that just to make it easy to remember, this has also been outlined by in the previous presentation by Advocate Mohale. Part B requires one to indicate which of the 8 conditions should one be exempted from. And so basically it's accountability, limitation processing, purpose, further processing, information, and openness. Yeah, just the ones that have been outlined, just not to waste time there. The big question is, why should one be or a body, a responsible party, be exempted? And we have already highlighted on these 2 aspects. And just to go into the explanations now, and as we have been touching on the contents of the application form, the main thing here is the issue of necessity. We cannot just allow any person or as a regulator or to process information in breach of the lawful conditions without any important necessary purpose. So that's why, in short, one could say that one, you need to indicate necessity. Now, the first necessity is what we can call public interest test, because now you have to indicate the reasons why it is necessary to process information by identifying the public interest. Now, the Act lists a few examples of what public interest is. For example, it will indicate, and graphically we can just easily read them here, to say that it's national security issues, prosecution of offenses, protecting financial interests of a public body, compliance with legal provisions, or for historical, statistical, or research activities, and perhaps also incorporating issues of freedom of expression. Now, the issue of public interest is a bit catchy, so we want to give a bit of a zoom into it at this stage, because it is being said that public interest in many sources, it cannot be defined. However, the regulator has attempted to provide a broad indication of what the position of the regulator, of the information regulator, is in this regard. And it says that it's a wide and diverse concept that cannot be packaged into a limited scope and application, and it will vary across a jurisdiction and should be assessed on such basis. It is a notion, in other words, that an action or process or outcome is widely or generally beneficial to the public at large, as opposed to being beneficial to a few or single entity or persons. Therefore, and it should be accepted in the spirit of equality and justice. That sounds a bit, still broad and a bit vague. However, Chris Wheeler tried to make it more specific and says that, for example, public officials have an overarching obligation to act in the public interest. For example, in the public interest when they're in government, or for the public as they are their customers. But also, the other view is that what can be considered public interest, that's not necessarily what the public is interested in or what the public will be in favor of. And perhaps they're not even aware or even concerned about that, which can be considered as public interest, which makes the concept quite interesting. A very catchy example there is when there is an increase in taxes and it is said to be for public purposes. Now that increase, it's important for the benefit, to benefit the country at large, hence we will deem it to be of a public interest. But generally, who becomes happy when we hear that a VAT is going to be increasing? So now the issue of public interest goes on to say, if you look at the cartoon there, it looks like a ball has broken a window, and the old lady there is now saying, what do we do now, my boy? Because now if we release this information, it might not be in the public interest. So, that goes to say that public interest is quite contextual. Hence, the regulator has to go on and make this assessment when you do apply. But it also depends on your motivation as an applicant or as a responsible party to indicate to the regulator, as we said earlier, how is your processing that is in breach of the lawful conditions now become something that is in the public interest. It depends on how you will provide that explanation to the information regulator when you do apply. Now, the second aspect that the regulator will consider prior to exempting or authorizing an exemption is what we call a clear benefit to the data subject or to the third party. Now, also in this case, prospective applicants or applicants, please specify the nature of the clear benefits that is to be bound to the data subject or third party, and explain how those benefits will outweigh to a substantial degree the interference with the privacy of the data subject. Situations are quite diverse, as we have encountered when you do assessment. So it is quite catchy to even give an example, because they, as we say, this moves from context to context, but it will depend on the applicant to actually indicate to the regulator how this benefits will outweigh. It must just not outweigh, it must outweigh to a substantial degree interference with the privacy. Remember, the issue here is that you would want to process information that is going to violate the privacy of the data subject. And then you're requesting that the information regulator to actually say, allow me to do so. So that is why the standard is actually a bit high, where it has to be a substantial, honestly. And part D, which is the last part of the application form, it's just the declaration where you have to indicate that the information that you have provided to the regulator is true and correct. Now, this is just to remind you, nature of the benefit really should be, like I emphasized, a substantial degree, for it to interfere with the privacy of the data subject. Now, what I was talking about is the assessment. Just to package it in one slide is that we will make reference during an assessment of what POPI as an act provides, what the guidance note have indicated to you to do, and what you have provided to us in the application form. And only after we have considered this information can the regulator now make a decision upon which the granting of this exemption will be published in a form of a notice in terms of section 37(1). We should not forget that this can only be done when we have managed to, as a regulator, to assess that indeed this processing that is in breach is in the public interest and involves a clear benefit to the data subject. where you need to perhaps, or you may have also realized that these two aspects are bracketed or joined by the word or, because it is not in all the cases that something that is in the public interest is also in a benefit to the data subject. So we do give cognizance to that aspect, hence the emphasis of the word or in the slide. Now, if we look at chapter 4, ladies and gentlemen, applicants and everyone, exemptions in respect of certain functions is provided for in section 38. And as the exemptions, the sections were explained by Advocate Mohale, I do not need to go into there, but the section 38 says a responsible party may be exempted from complying with certain sections, and those are listed there at section 11, 15, and 18. Now, relevant functions for purposes of section 38 will mean that you are either a public body or you are conferred, there is a conferred a functionality on a person in terms of the law, which is performed with a view of protecting members of the public against these two aspects: financial laws due to dishonesty and other factors there, or dishonesty due to malpractice and or other seriously improper conducts here. Now here we're looking at public entities and other bodies that deal with issues of investigations or reflection of fraud and stuff like that. I mean, the section is quite self-explanatory. Now, just to remind you that, when section 38 says it will exempt you from certain functions, it says, for example, where you were supposed to get consent and you are not able to, you'll be exempted through section 38. Or else not being able to collect information directly from the data subject, which is a requirement to comply with the conditions. But in this case, we're saying that you are exempted from not being able to do so. Further processing to be compatible with the purpose. Sometimes you process information, but you need to adapt the processing to another purpose. And but this section will exempt you, as well as notification to data subject when collecting personal information. Now, in any case, to the extent to which this, the application of this proviso applies, this exemption should be done to the extent that that is likely to prejudice to the discharging of that function that you request, that allows you to be exempted from this condition. In other words, where trying to comply with the sections will make it impossible to discharge your functions, that is when this section 38 may be considered in those circumstances. Now, that is just to explain section 38. You will realize that, the transitioning is quite a bit dramatic, because what we're talking about here is a bit of a sensitive provision in POPI. Sensitive in the sense that it may not be in the public interest for the regulator to allow any responsible party to be exempted from this particular provision. Although, remember that, section 37, it's saying you are exempted if granted from complying with the lawful conditions for processing of information. But imagine the issue that we as a country and many other countries are facing that pertains to information security. Now, if we look into section 19 and section 22 of POPI, they are talking about security compromises. And as much as, there can be condonation of the lawful processing of information, it might not be possible in many circumstances to allow a responsible party not to ensure the integrity and confidentiality of information in its possession or under its control. So, but then if you look again in section 22, it says that section 22 provides for situations where there are reasonable grounds to believe that personal information has been accessed or acquired by an unauthorized person. And section 22, ladies and gentlemen, colleagues and everyone, if you look at it, it says should a situation of this nature occur, the regulator must be informed. So, and we also look at section 37(3), if I'm correct. It will tell you that the regulator may impose conditions other than the ones that you are requesting to be exempted from. So I think we need to understand that we are living in a digital world, and we are facing a global pandemic where information security is really at stake. So section 19, in short, will request you to identify a reasonably foreseeable internal and external risk, and this will help you to anticipate any occurrence of risk. But regularly, just also verify that the safeguards that you have implemented are still effective. This is just to ensure that we do not find ourselves having to suffer from any form of security breach. So now, one of the other things is what Advocate Mohale alluded to in terms of who is responsible. I will really not indulge into that, because we also need to remember, this is just a reminder that there may be two people or two types of processors here who deal with information, an operator and a responsible party. And in the definition is made very succinct in section 1. What is critical if we look into accountability at this stage is to indicate that POPI recognizes accountability as a fundamental condition or principle. Now, if we say that we need to exempt people from this, from complying with accountability, we can all discern that that may not necessarily be in the public interest. So in short, ladies and gentlemen, we are appealing that, as Advocate Waypoint indicated in the introduction, that when we interpret these sections, we need to cross-reference, and that may be catchy, but we need to look at how one section affects the other so that we do not see this as a contradiction. We do not see the provisos as a contradiction, but rather as a complementing each other. With that, I would like to express what Kitty is showing that as a thank you. Thank you, Ms. Louise. I'm handing over to you. Thank you.
Thank you very much, Ms. Lamola, for a very detailed presentation. There are a number of questions in the Q&A, and one question I'd just like to raise, which we will discuss later, is the issue of information of the employer, of the employee to the employer. So for example, an employer wants to know how many of his or her employees have been vaccinated. Is that a breach of the POPI? Let me leave that question for the next speaker. So a number of questions are being raised in the chat box, and they are attended to by the executives of the Information Regulator. Our third presentation, ladies and gentlemen, is about the applications for prior authorization. And I'm going to invite Mr. Nemasisi, the executive of PAIA, the Public Administration Information Act, to come and talk to us about applications for prior authorization. I think I might have got the name of the act incorrect there. Please, Mr. Nemasisi, correct me there, please.
Good morning, the program director. Good morning, DDG colleagues from the NSG, and good morning to member of the Information Regulator, Advocate Waypoint, And good morning, colleagues of the Information Regulator. Indeed, this is the application for prior authorization under the POPI. It's not under, although I'm an executive for PIA, but I'll be presenting under the POPI division. Thank you so much. After the previous speaker, and with so catchy and all those smileys, my presentation does not have those. But it was a very good presentation. Thanks a lot for laying the ground together with Advocate Mohale. I will be talking about the prior authorization. It's a very complicated process, and most of the people have been asking a lot of questions about this process. So this presentation will deal with what is it that you are required to do in order for you to be prioritized, and what are the processing that require prior authorization. So my discussion, looking at the time, I'll deal with the introduction. I'll also deal with the issue of processing. What are the processing that are subject to prior authorization? What are the requirements insofar as notification to the regulator on any information that require prior authorization? And also I'll deal with the issue of suspending processing whilst you're waiting for the regulator to make a determination on your application. We'll deal with the process on how the application for prior authorization should be submitted to the regulator. And upon receipt of that application, we'll deal with the timelines within which the regulator is required to process that application. And we'll also deal with what are the criteria, because as a regulator, we're a public entity, and therefore we need to be open in our processes. We'll then deal with the criteria that the regulator use in processing those applications for prior authorization. I'll end the presentation with what are the offenses in instances wherein you do not comply with the requirement of prior authorization. So deal with the offenses and what are the penalties. And that would be the end of the presentation. You can go to the next slide. Thank you. So the POPI, as already indicated by colleagues, aims to promote the protection of personal information processed by public and private bodies by, amongst others, introducing the minimum requirements for the processing of such information. What are the minimum requirements? Those are the 8 conditions which Advocate Mohale has touched on that. I'm not going to deal with those because she has dealt with those 8 conditions. But those are the key 8 conditions that for you to say you comply with POPI, you need to be compliant with those 8 conditions, unless you're exempted, as Ms. Lamula has indicated. The regulator is, amongst others, empowers to monitor and enforce compliance by public and private bodies with the provision of POPI. Next slide, please. So if you look at section 57, it requires public and private bodies. Those are the ones that Ms. Lamula indicated they are responsible parties. So it requires the responsible party which intends to process certain categories of personal information. And these are the information that are classified as high-risk processing, or processing that carries a particular risk. And for those processing of those personal information, you are required to obtain an authorization from the regulator prior to such processing. So in other words, currently there are those people who are processing. So when section 58.2 comes into operation, you then have to stop processing until such time you obtain the authorization to process. Currently, there are 4 categories of high-risk processing of personal information in which prior authorization is required, although the regulator does have power in terms of section 52 to determine any other category that may be subject to prior authorization. Next slide. So the responsible party, which are indicated to be public or private body, must obtain prior authorization only once, except where the processing departs from that which has been authorized by the regulator. So let's say, for example, you process, you've got different ways of processing personal information. You do not have every time when you intend to process personal information, which information falls under the prior authorization. You do not have to every time submit an application. You make application once it's granted, you are actually going to do, you'll be allowed to process it forever until as much as your responsible party exists. But unless that processing has now depart from what has been authorized, then you can make it a new application. But otherwise, the application does not, the authorization does not expire. Unless a code of conduct has been issued by the regulator and has come into force in a specific sector or industry or sector of society in which responsible party operates, the responsible party who is currently processing or intend to process personal information which is subject to prior authorization must submit the application prior to the commencement date of Section 58.2. Advocate Weapon touched on the effective date of Section 58.2. I will confirm that in the next slide. But the important thing about this is that you've got sectors. I'll give an example of banking sectors. So the banking sector may decide to have a code of conduct which regulates the way in which personal information will be processed. And if their code of conduct is approved by the regulator, therefore, none of the banks will be required to submit an application for prior authorization. The next subject is the processing subject to prior authorization. Next slide. So the following are categories of high-risk processing of personal information in which prior authorization must be obtained. I think before I go into those categories, let me explain why do we call them high risk. Most people will say, but if I obtain consent from the data subject, why should I then be required to make a prior authorization? Because this processing has been categorized as high risk, irrespective of whether you comply with all 8 conditions, you need to obtain authorization from the regulator prior to processing those personal information. That's because the nature of the processing has been classified as a high risk. And it doesn't matter whether you've got consent or whether you comply with all 8 conditions. As much as processing falls under those categories, you have to obtain the prior authorization and the regulator will process such an application. So the first category is and I'll give a practical example of these categories. For now, I'm just going to list them. The first one is the processing of a unique identifier for purpose of data subject for purpose other than one for which the identifier was specifically intended at collection, and with the aim of linking the information together with the information processed by the other responsible party. So in this instance, the unique identifier refers to your ID number, for example, your account number, your policy number. For you to be able to identify what constitutes a unique identifier is something that if you punch into the system, it will then give you all the personal information of a person. So for example, if you put the personal number of NEMACC into the finance system of the government, all my information will come up. So that will constitute a unique identifier, because by just putting that number, my information, my address and everything will appear in all my qualifications. So if the processing of the unique identifier, so there's different, the aspect that you need to look at in this one is that there must be a processing of unique identifier, and they must be done for other purpose than the one in which it was intended at collection. But it doesn't end there. There must be a linkage of that information with the other information processed by the other responsible party. There must be 2 responsible parties, and there must be 2 different purposes in which the unique identifier is being processed. But I will give a practical example at the following slides. The other category of processing which is subject to prior authorization is the processing of personal information or data subject on criminal behavior or unlawful objectionable conduct on behalf of third parties. I will give an example, but this is, for example, where, for example, you apply for employment and your information is then you're being searched for whether you've got criminal record or not, or they're checking a background check. So those are the processing it has to be, you need to apply for prior authorization, but I'll give a practical example on that as well. The other category is the processing of personal information of data subject for purpose of credit reporting. This is actually applicable to the credit bureau, the registered credit bureau, those entities that are registered with the National Credit Regulator as a credit bureau. For them to process our personal information, they require prior authorization from us. In other words, if come February next year, they have not gotten a prior authorization, those credit bureau will have to stop processing our personal information. The last one, next slide. The last one, which is a very, very critical category of personal information, which is subject to prior authorization, is the transfer of special personal information or transfer of personal information of children. But that transfer should be, if you only apply if that transfer of special personal information or personal information of children, if you are transferring to a third party in a foreign country that does not provide adequate level of protection for processing of personal information as referred to in Section 72. In other words, if you are transferring a personal information to a country that does have that adequate level of protection, you do not necessarily have to apply for prior authorization. This is only applicable in instances where you are a responsible party in South Africa, you intend to transfer personal information outside the country. The practical example will give a practical example, but most of the instances wherein personal information gets transferred from the public to the other countries is through the cloud, where our information gets stored in a cloud. And we find that this cloud is situated in the other country. And the main issue will be to check whether that country where in the cloud, our information is stored in the cloud, is actually stored in the country that has adequate level of, in other words, they've got data protection laws or privacy laws. If they don't have that, then you need to apply for prior authorization, and the regulator will assess and check whether you should be allowed to transfer such information outside the country. So this is a very important condition that we need to adhere to. So now I'm going to give the practical example on each of the 4 categories that we have so that we can make this processing more understandable, because there's been a lot of confusion. A lot of people have submitted application in respect of processing, which does not even fall under those categories. So the first one that we indicated, we said it's when you're processing a unique identifier of a data subject for a purpose other than the one for which the identifier was specifically intended at collection, with the aim of linking the information together with the other information processed by the other responsible parties. Practical example, so you've got ABC company, which is a financial service provider. It collects your ID number of the ID number of a data subject for purpose of providing credit. So you go to the bank and say, I want to apply for the credits at the bank. So there's an application form. The purpose of your application, when you give them your ID number, is for them, your purpose for submitting that information is for you to get credit. That's the main purpose why you're giving them your ID number, your payslip, your banking details, and your qualification. In some instances, some people require your qualification. The reason why you give those personal information, including the ID number, is because you want credit. So that's the purpose A. And therefore, the bank then receives your application for purpose A, which is for credit, for you to get the bond. They then say, before we grant you an application, I'm going to check your credit worthiness. What do? They take your ID and go and link it with the information that is being processed by a third party. With the third party is the credit bureau. So they link your ID with the credit bureau. And that is the purpose B. What is the purpose B? Is for them to check your credit worthiness. So you didn't apply for credit worthiness, you apply for credit. But then the bank says, before I give you credit, I need to check your credit worthiness. I'll use your unique identifier to check the credit, and they link it with the information that belongs to a credit bureau. Such processing require prior authorization. And that's the one example on which a unique identifier will be linked for other purpose than the one in which it was intended at collection, by linking it with the information that processed by the third parties. So in this instance, one person will say, but there's no way that you can apply for credit without the financial institution checking your credit bureau. That's correct. And that falls under one of the conditions that Ms. Advocate Muhalde referred to, is the compatibility of the further processing. Remember, if you look at the condition that refers to further processing, is that the initial purpose and the second purpose must be compatible for it to be in compliance with the Act. So that would be the ground upon which the regulator will grant such an application for prior authorization to the bank, to say for you to process personal information, because the nature of the processing is compatible with the original purpose, and therefore it complies with one of the 8 conditions, and that's the ground why the application should be granted. Next slide, please. The second processing example that I want to give is with regard to the processing of personal information of data subject on criminal behavior or unlawful or objectionable conduct on behalf of third parties. I'll give the same example of the company ABC. It intends to appoint an employee, but such appointment is subject to the criminal or background check. It's very prevalent in the public sector that before you appoint a person, you'll check the criminal record. You'll even check the background check, where, for example, check whether this person has been charged before, for disciplinary action has been taken against this person before, or even the previous conduct of that person. So it's company A, it intends to appoint an employee, and such appointment subject to those criminal and background check. Then the company A will then appoint company DEF company is appointed by ABC company to conduct a criminal and background check on its behalf. Normally, you'll find that as a regulator, when we intend to appoint somebody, we're going to appoint another company that conduct background check, that also conducts criminal check, to say, please check, do the criminal and background check for this employee, that we intend to appoint. So in this instance, the company that's supposed to apply for prior authorization, it is not the regulator, which is the employer. It is the company that is appointed by the employer to conduct, because they are the company appointed is the one that actually supposed to apply for prior authorization before it processes, which means that the regulator, when they appoint company B to assist them in conducting the criminal check or background check, they need to ensure that before they appoint such company, they need to satisfy themselves that that company has obtained a prior authorization from the regulator. In other words, they must prove that they've been authorized to do that work before the regulator appoints that company. Next slide. The third one is the processing of personal information of data subject for purpose of credit reporting. So if you're to look at a given example, is that you've got big companies like Experian, TransUnion, Very Credit, and XDS. These are registered credit bureau. They're registered with the NCR, and they process personal information for purpose of credit reporting. And we need to be careful with regard to credit reporting. There's two different of credit bureaus. There's a credit bureau that provide credit, they create a credit report. These are the big ones, you Experian, your TransUnion. There are those that they actually are resellers. For example, LexisNexis, they are actually the resellers of credit bureaus. So LexisNexis, because they don't create a credit report. They just take a credit report that has been done by TransUnion, for example. They sell it. It's a reseller of credit report. They do not have to apply, but the credit bureau, those that are processing our information, they create a credit report based on our personal information. Those responsible parties must obtain prior authorization, and if they do not obtain it, they need to be stop processing. But that can only happen once the Section 58.2 comes into operation, which we'll deal with it in the next few slides. Next slide. The last one is the one which I said is the more critical one, where we transfer the special personal information or personal information of children to a third party in a foreign country that does not provide an adequate level of protection. So ABC company is an international company operating in several countries, and some of the countries in which special personal information or personal information of children may be transferred does not have a privacy law. So in other words, they are transferring an information to Namibia. I've given a practical example. Namibia does not have a privacy law at the moment. So if you're transferring personal information, that country does not privacy law, it means automatically you will have to apply for prior authorization. Or if you are transferring, it's not only any information, it's a special personal information or personal information of children. If there is no privacy law, then you need to then apply for prior authorization before you do so. The important thing here is that the regulator has not conducted an adequacy assessment of the country. So at this stage, we cannot provide you with the list of the countries that have privacy law which provide adequate protection of the personal information of data subject. It's something that the regulator is considering to provide that list so that the responsible parties will know which countries have sufficient legislation. But at this stage, it's still early for us to be able to do so, but we will definitely do so in the near future. The next slide. So we deal with the issue about notification. I indicated earlier on that when you are processing is subject to prior authorization. In other words, your processing fall under those four categories that I deal with. You are required to notify the regulator that your processing is subject to prior authorization. Next slide. So a responsible party who intends to process personal information, which is subject to prior authorization, is required in terms of Section 58 of POPI to notify the regulator of the intended processing. To simplify the process, the regulator has included the notification in the prior authorization application form, and there's no need for a separate notification from the application for prior authorization unless the said responsible party does not intend to apply for prior authorization. So in other words, the legislature requires that you need to notify the regulator that you are processing personal information and that processing is subject to prior authorization. You need to notify the regulator. It also requires that you must apply for prior authorization. So what we did when we created the application for prior authorization, automatically when you apply for prior authorization, you are simultaneously notifying the regulator of the processing. So there's no need to have two separate processes where you notify and apply separately. So by filling an application form, automatically you are actually notifying the regulator. Next slide. I think you might have skipped. Just want to check quickly. Oh, no, that's fine. Thank you. So after you notify the regulator that you are processing subject to prior authorization, the Act requires you to suspend processing of personal information. So immediately when you submit your application for prior authorization, you need to stop processing. You cannot continue processing that is subject to prior authorization. You can move to the next slide. You cannot continue processing any processing that's subject to prior authorization until the regulator has completed its investigation or until you have received a notice that a more detailed investigation will not be conducted. So in other words, once you you make an application to the regulator, you need to stop processing. In other words, you need to suspend processing until such time the regulator has authorized you or have authorized you to continue with the processing. However, at this stage, the regulator has determined the 1st of February as the date in which the Section 58.2 of POPI shall become applicable. What does that mean? It means that at this stage, there is no requirement for you to suspend processing, which is subject to prior authorization. So all responsible parties who intend to submit an application or who have submitted an application for prior authorization, they can now process those personal information in the meantime, while the regulator is processing their application, because the effective date of the section that deals with suspension has been moved to the 1st of February 2022. That means that application for prior authorization must be brought at this stage, because from the 1st of February next year, all processing of prior authorization will have to stop immediately. You can move to the next slide. So once you have submitted your application for prior authorization, then what is the process? What is the manner of submitting application to the regulator for prior authorization? Next slide. So there is different ways in which an application can be submitted to the regulator. The first one is to send an application through an email. This is the email address where an application for prior authorization should be submitted. I must say that because we are under the pandemic, we prefer that application should be sent by email, and that's because if you send them by postal or physical address, there might be a chance that the transmission of virus through the postal might occur. So we encourage people to submit through by email, but those who are unable to do so, they can submit it using our postal addresses. They can also deliver it at our offices. Those applications can be delivered at our offices as well. Next slide. Next slide. What are the timelines for processing an application? What happened when we receive the application for prior authorization? So the regulator is required to approve or reject the application for prior authorization within 4 weeks of receipt of that application, unless the regulator decides to conduct a detailed investigation. So when we receive your application, we've got 4 weeks, which is a month, to process that application. We'll decide whether to grant it or not to grant it. But if the application, your processing is so complicated, I'll give an example. If, for example, you said you are transferring the special personal information outside the country, and the regulator is not to make a determination as to whether that country has got adequate level of protection or not, that may require additional time for us to conduct such an assessment to check the country in which you are transferring. And because we may need additional information, we may decide to conduct what we call a detailed investigation. Should the regulator decide to conduct detailed investigation, we will inform you as the applicant to say your application for prior authorization has been received. We do require to conduct detailed investigation. We'll give reasons why we want to conduct detailed investigation. We'll also give you the timelines within which the detailed investigation must be completed. But in terms of the Act, the detailed investigation should be completed within 13 weeks. But it does not mean that the regulator must take 13 weeks to conduct detailed investigation. You might find that it may take additional 5 days over and above the 4 weeks that we have to finalize the detailed investigation. And once a detailed investigation is conducted, then we'll be able to issue a statement. You can move to the next slide. So once you receive the application for prior authorization, the question that the public may ask is that, what are the criteria do you use in assessing the application for prior authorization? So we've got 3-stage assessments. that we follow. The first stage is the way in which we assess if the application falls under any of the exclusion. You remember, if you go to section 6 of POPI and section 7 of POPI, they provide for an exclusion, which means there are certain processing that do not fall under POPI. In other words, for those processing, you don't have to comply with POPI. And those you find them in section 6 and 7. So the regulator, before we assess your application, the first thing that we do is to check whether your processing doesn't fall under any of those processing. And if it does, it means your application will not be processed further, and we will advise you that your application falls under exclusion, and therefore you do not have to apply for an exemption. That's what's going to happen. But if it does fall under POPI, then we move to stage 2. The stage 2, that's where we determine whether processing is subject to the scope of the prior authorization. You remember the 4 categories of processing which is subject to prior authorization. So we conduct a verification of whether indeed your processing fall under any of those categories. Once we confirm that indeed your processing fall under any of those categories, we move to stage 3. This is the last stage. The stage 3 is the one in which we assess if such processing is compliant with the 8 conditions. These are the conditions that Advocate Mohale touched on them. So that's the last stage that we conduct an assessment. We check whether you are processing personal information for credit reporting. We then check about whether such processing, is it lawful? Is there any further processing? I'm sure you remember, colleagues, there was a data breach by Experian, wherein over 24 million of our personal information has been leaked. And those are the issues that we're going to check when we assess the application from the Credit Bureau. We'll check whether is that processing in line with the 8 conditions. If we find that over and above what they do, which is the credit reporting, they do further processing, and we check and find that that further processing is not in line with POPI, we will not provide them with an authorization, and that means they will have to stop processing until such time they comply with all 8 conditions. So it's a 3-stage processing. At stage 1, we assess whether there's any exclusion. Stage 2, we determine if indeed your processing fall under the 4 categories. Stage 3, we check whether once it falls under the 4 categories, do you comply with all 8 conditions, unless you're exempted. So if, for example, we find that you do not comply with all 8 conditions, we will reject the application. And the only means in which the application can be granted is when you obtain an exemption, as Ms. Namula has touched on it. Next slide. So what are the offenses for failure to notify processing which is subject to prior authorization? You remember earlier on I indicated that you need to notify the regulator that your processing is subject to prior authorization. So a responsible party who fails to notify the regulator of any processing that is subject to prior authorization in terms of section 58 of POPI, it's in virtue of offense. I'll give an example. If any of the credit bureau fails to apply for prior authorization, when we know that their processing is subject to prior authorization, it means they'll be guilty of an offense. So a responsible party who has notified the regulator. So you have notified the regulator. In other words, you've submitted an application for prior authorization, but you continue with the processing. In other words, you did not suspend processing pending the determination of the regulator. Such conduct is also an offense. And by the way, don't forget that we said at this stage that you are allowed to process personal information because the section 58, the suspension will only kick in on the 1st of February next year. But from the 1st of February next year, if you notify us and you continue processing before the regulator takes a decision, it means you committed an offense. Then we deal with the penalties in the next slide. What are the penalties for failure to notify processing, which is subject to prior authorization? So any person convicted of an offense for failure to notify the regulator of any processing that is subject to prior authorization, or who carry out processing of personal information which has been notified before the regulator, the investigation is completed by the regulator, that person will be liable to a fine or to imprisonment for a period not exceeding 12 months, or to both fine and such imprisonment. One of the questions that we get from the stakeholders is to say, how do you imprison a responsible party? Because the responsible party is the one that's supposed to make an application for prior authorization. And the Act says you can be fined and imprisoned at the same time, but you cannot send a company to prison. The issue is that the fine obviously will be payable by the responsible party. But where the court decide to sanction an imprisonment, it means the person who is responsible for allowing the processing contrary to the POPI, that person will be the one who breached POPI and is the one who's going to go to prison. So not the company will not go to prison. The company will pay the fine. But if the somebody is supposed to go to prison, it will be the person who allowed it. The first suspect, I must say, is the information officer. So if you are a department, the DG will be the first suspect, unless the DG indicate that I was not responsible. If you are the company like the information regulator, the CEO of the information regulator will be the first suspect to allowing that processing that is contrary to the POPI. So those are the responsibility with Advocate Mohale of the information officer, that you need to be very careful with regard to what is it that you allow to be conducted, because otherwise you'll end up being in prison for not complying with POPI. Next slide. So the other offensive penalties for failure to comply with the statement concerning the unlawfulness of the information processing. So earlier on, I indicated that we have got 2 periods within which timelines within which we need to comply with when we process application for authorization. The first one is 4 weeks, and the second one is 13 weeks. And 13 weeks is when we decide to conduct what we call a detailed investigation. So the decision of the regulator following a detailed investigation will be issued in a form of a statement concerning the lawfulness of the information processing. In other words, we will issue a statement once we conduct a detailed investigation. However, should the regulator find that the information processing is unlawful, in other words, we found that the processing by the credit regulator, the credit bureau is unlawful, so that we would, in such statements, the regulator shall be deemed to have been an enforcement notice. So when we issue a statement wherein we find that the processing is unlawful, in other words, we cannot grant an authorization, such statement is considered as an enforcement notice. So a responsible party which fails to comply with the enforcement notice, in other words, if we issue a statement to say your processing is unlawful, please stop it, and you fail to comply with that statement, which is an enforcement notice, you will be guilty of an offense, and upon conviction, you shall be liable for a fine or to imprisonment period of not exceeding 10 years, or to both fine and such imprisonment. One of the questions that we've been asked was, how much fine can the regulator impose? You'll see that there's a fine that the regulator can impose of about 10 million, not more than 10 million, and there's a fine that can be imposed by the court. That fine has not been specified. The maximum amount is not specified in the regulation. That will be determined by the court depending on the aggravating or any circumstance that you may have submitted to court. But in terms of the fine that the regulator can impose, it's a fine of about not more than 10 million. Next slide. In conclusion, currently we have over 200 applications that have been assessed, and the responsible parties should expect decision between now and the end of January. So there is a lot of applications that we have received. So far, over 200 applications has been assessed, and we are in the process of taking decisions, and communication will be made between now and November and the 1st of January 2022. So as I indicated earlier on, the commencement date of 1st February for suspension of any processing of personal information which is subject to authorization, that suspension will commence on the 1st of February, and there is no intention from the regulator side to extend such. So which means responsible party who have not applied for authorization are encouraged to submit the application by end of November 2021. Lastly, the guidance note on application for authorization and the application form are being reviewed, as other 7 conditions for lawful processing of personal information were not covered as part of the assessment application for authorization. This means that if you look at the guidance note and the application form, the responsible party were required to indicate how do they comply with only one condition. Ms. Mohale touched on that condition, the security safeguard. We did not request the responsible party to touch on other conditions, and that was an oversight, and that's why the guidance note is being reviewed. So as soon as we finalize the review of that guidance note, it will be publicized together with the new application form, wherein you're supposed to then deal with all 8 conditions. At this stage, for those people who have submitted application for authorization, wherein you only provided your explanation of compliance with only one condition, which is security safeguard, you will receive notification from our personnel who are conducting assessment. They will request you to submit information regarding the other 7 conditions, because when we process this application, we need to consider all 8 conditions and not only one condition. Next slide. Thank you so much, Program Director. That's the end of our presentation.
Thank you very much, Mr. Nemasisi, and thank you for a comprehensive presentation on the applications for prior authorization. There are a number of questions in the question and answer box, and I'm asking for our esteemed panel of guests to please respond to the questions. We don't have much time left for our webinar session, and we thank everybody for listening in and for participating through the QA. I'm just going to take 3 questions, and specifically, as indicated in the chat box, can I ask a question to Advocate Weapons? Sipo Kokela says, hi, for statistical collectors, the transition to POPI Act has brought more reluctancy from data subjects. We collect statistical data within the Statistical Act, 1999, Act number 6 of 1999. We also clearly explain the benefits of information being collected to the data source, but unfortunately the data source or data subject does not provide the data requested. Which acts, POPI Act and Stats Act 1999 supersede or outweigh the other? And how can data discharging departments or organ of statement use the POPI Act as required? So the question, Advocate Weapons, just in terms of time, something short and succinct, please.
Thank you, Ms. Lupin, and thank you so much for the question. I think what is very important with regards to the supremacy of the 2 acts, POPIA is only applicable and would supersede in circumstances where POPIA provides more protection than any other act, or in the circumstances if the Statistical Act that's referred to provides more protection than POPIA, then that act would prevail. So that's the difference or the distinction between the 2. But very importantly, because I have to keep my answer short, if you look at Section 14 of POPIA, it clearly outlines the fact that there is also an opportunity to collect such data if it is in terms of the Statistical Act for research, historical, and statistical purposes. So those will then tie in there. I don't want to go too far and elaborate too much because of time constraints, but I would like to direct you there. Over to you, Ms. Lupin. Thank you so much.
Thank you very much, Advocate Weapons. There's a question for Mr. Nemasisi. I hope you managed to catch your breath there. Mr. Nemasisi, our anonymous attendee asks, where can I obtain information on the information officer of a multinational company? It was mentioned that the information officer must be based in South Africa and must be an employee of the company. Is that correct? What if the multinational does not have employees in South Africa? Can a contractor agent then be appointed as the information officer? Mr. Nemasisi?
Thank you so much for that question. If you look at the requirement of appointing an information officer is to ensure that a body, public or private body, are accessible to the data subject and also the requesters, which is the public who might require access to the personal, to the information that they require. So if you don't have information officer in the country, then it means the issue of accessibility becomes a challenge. We also cannot be able to hold them accountable. So in instances where in a company, a multinational company, which head office is somewhere in outside the country, but they've got a branch here, then they can appoint, designate an information officer in the country. But the question says there is the company does not have a branch here at all, but it operates outside the country, it operates in the country. They are allowed to designate an employee, but that employee must be situated in the country for us to be able to for them to be able to be accessible, as well as for those people to be able to for us to hold them accountable. But it might be difficult for us to hold anyone accountable who are not based in the country. Yeah.
Thank you very much, Mr. Nemasisi. Another question for Advocate Mohali. Anonymous attendee asks, Advocate Mohali, if you fail to be appointed for a post you applied for and attended the interview, when you request the memo of approval by the panel to the MEC, including attached documentation that includes the qualifications, can this information be viewed as classified and cannot be made available subject to the consent of the applicants? I am of the view that a qualification is part of the submissions that form part of the tolls used for you to contest the post. You're therefore entitled to know if the appointed person has the correct qualifications or not. Over to you, Advocate.
Thank you, Ms. Lepan, for the question. I think, as Advocate Weapon mentioned earlier, when we do look at such questions and processing of personal information, we cannot look at the legislation in isolation. So POPI does allow for where other legislation overlaps with POPI, that we take them into consideration. So if this person who did not receive or was not appointed needs access to another person's information, we need to consider if they have the necessary authority to gain that information. If in terms of PIA, that person has a right that they are protecting, then they would need to declare so, and still they would need we would need some legal basis to share that information with another person. So we protect the failed applicant and the successful applicant. Thank you, Ms. Lepan.
Thank you very much. Ms. Lamola, are you there? The question is from Oduetse Gabonwe. Please excuse me if I'm not pronouncing it correctly. Is it authorized for journalists, this is your fourth estate, to publicly share health information of the subject? Who has to be held accountable on how the journalists acquire the information? Because they always say they can't disclose such since they are trying to protect their sources. Ms. Lamola, are you there?
Yes, I am. Ms. Lepan.
It's about the rights of the journalists vis-a-vis the rights of the data subject.
I've actually already answered in the chat. I think it was quite easy to refer to section 7 of POPI regarding exclusion for journalistic, literary or artistic purposes. And I emphasized in the chat that if you look at the provision, the processing, cannot be excluded from the public interest issue, which must now be compared with the right to privacy. So there's some kind of balancing of rights that has to happen there. However, also to indicate that the exclusion of journalistic work from the lawful processing is not without any restriction, because there is a code of ethics that is provided for in the very same act. And should it be that someone finds that the code of ethics for journalists does not provide adequate safeguards for any of the issues they have, so the very same section provides for events of dispute. Section 3 in short says that in the event that a dispute may arise in respect of whether adequate safeguards have been provided for in the code, then certain conditions have to be taken into consideration. So I did refer the asker or the person that made a question, that asked the question, to section 7 like we indicated in my presentation in particular, that some of the authorizations or exemptions happen because the processor or the responsible party is bound by other laws. They can be held accountable through those other laws, including such codes of conduct. Yeah, thank you. I think.
Thank you very much. To all the executives and members of the Information Regulator, I would like to thank you very much
Ms.
for,
Lepan,
yes.
Are you unmuting yourself perhaps? You want to unmute?
I am there. Can you hear me?
Yes, we can. Yes, you can, Ms. Lepan.
Thank you very much. I just want to thank all the colleagues from the Information Regulator, Advocate Weapons. Thank you very much for bringing your team
Ms.
along.
Lepan, you're on mute.
I'm not, thank you very much. Can I ask Dr. Marja, please, just to say some closing remarks, and then ask everybody, please, just to do the Lime survey that is posted in the chat box. Thank you very much, Dr. Marja. Over to you.
Thank you very much, Ms. Lepan. Thank you very much to our very knowledgeable colleagues from the Information Regulator. At the National School of Government, our motto is comprised of 3 words: learn, serve, and grow. And I hope that this morning we've been able to achieve all those 3 elements. I hope we've been able to learn. And with that learning, I hope we'll go back to our desks this afternoon and on Monday onwards to be able to serve. We are not just having talk shops for the sake of talk shops. We are doing this to inform and make sure the serving that we are supposed to do as public servants takes place. So we really hope that you will be able to serve out of this. But more importantly, we must all grow. So you don't learn and serve but not grow. You have to learn, serve, so that you are able to grow. So we really work hard at the National School of Government to make sure that these seminars, these webinars, and the master classes that we have help us to achieve those 3 goals. I hope that as we end this session, you will leave at least satisfied that you've achieved all those 3 elements, if not 1 or 2 of them. Next week, we are here again, as I indicated at the beginning, on Wednesday afternoon, 10 November, 3 o'clock, 1500 hours. Follow us, National School of Government, on all social media platforms where you'll be able to access the relevant links. We are talking youth. Today, we're talking POPI. So we hope that through these sessions, you keep on coming back, you keep on learning, you keep on growing, and you are able to serve. All the best and enjoy your Friday afternoon. Thank you very much.
Thank you very much, Dr. Marja. The session is closed now.